All right, I have 12:01, so we're going to go ahead and get started. Hello, everyone. Welcome. Thank you for joining us today. Today, we're going to have a special invited guest, Lisa Kim, Deputy Attorney General with the California Department of Justice. Our topic is going to be about lessons learned from CCPA enforcement and rulemaking. This is not a MCLE credit. It is a Zoom webinar, and this is being brought to you by the Privacy Law Section of the California Lawyers Association. This event is also jointly sponsored by the IAPP. Thank you to the KnowledgeNet chapters in the Bay Area, San Francisco, and also Silicon Valley. All right, so we're going to start by telling you a little bit about Lisa. Lisa, thank you very much for joining us. She is an active member of the bar in California and actually did another event with us with CLA last September, I believe. And your boss, Stacy Shasser, supervising Deputy Attorney General, also spoke with CLA Privacy. I think that was the inaugural event in November of last year. So welcome.
Thank you. Thanks for having me.
It's a privacy bar association representing all California lawyers. And the Privacy Law Section was established in November in recognition of the role that privacy lawyers play, especially in the state of California. So we have been really focused on CCPA and CPRA since the section was established last November. And we're really lucky to have Lisa talk with us today. She is the Deputy Attorney General in the Privacy Enforcement and Protection Unit of the Consumer Law Section of the California Department of Justice. She joined the office in 2015, and she enforces state and federal privacy laws, promulgates privacy regulations, educates Californians on their rights and strategies, protecting their privacy, and encourages businesses to follow privacy respectful best practices, and advises the Attorney General on privacy matters. Lisa earned her BA magna cum laude from University of California, Los Angeles, and her JD from the University of California, Berkeley School of Law. And I understand that the the new AG was confirmed today.
Yes, I just got word via email, and I'm sure everyone saw it on the news outlets. So we have a new official AG. Haven't gotten the chance to meet him yet, but I look forward to working with him.
Fantastic. So thank you very, very much. And I will save my bio at the end. Both of our bio and information is at the end of the slides. So let us know if you have any questions. I'm not giving away Lisa's contact information, sorry, but but you can find my contact information at the end. All right, so let's get started. We have an hour for this chat today. So first of all, can you start by telling us a little bit about how the privacy unit is structured and the role that it plays?
Yeah, so to start off, I just want to make this disclaimer. I work for the California Attorney General's office, but all the views are all my own and should not be attributed to the AG himself or to be considered formal positions. They reflect my personal opinions and experience, but hopefully you'll find them useful. Just to answer the question regarding the privacy unit. So in case you didn't know, the Attorney General's office represents California in a lot of matters. So I believe there's something like over 1,000 DAGs working in the office. The privacy unit is specifically a subsection of the consumer protection section, which is within the public rights division. So the public rights division is the division that holds basically represents California interests when it comes to environmental concerns, antitrust issues, civil rights issues, consumer fraud, deception, protecting consumers, that sort of thing. And so charitable issues as well. And so the consumer protection section is meant to be enforcing California's prosecuting any unlawful, deceptive, unfair business practices, as well as privacy violations. The privacy unit is a subsection of the consumer protection section, but there's a lot of intermingling within our consumer protection section as well. There are many consumer protection DAGs that help us out in our investigations and vice versa. For example, when we had the Johnson & Johnson trial not too long ago, I think it was a full section effort. A lot of us worked on it. There's probably not a single DAG that didn't have some part in that team. So just to give you a little background on that. With regard to the CCPA and the privacy section, you know, I want to kind of take a step back and explain, you know, the AG's office did not draft the CCPA. We inherited it, as well as the rulemaking aspects of it. It was not something that we were necessarily in on in the beginning. But that being said, once we were given the roles and duties ascribed to us, we took it on with a fervor. I was involved, like adopting regulations was not something that the privacy unit had done before, or I don't even think the consumer protection section had worked on adopting regulations prior to this. There are other sections in the AG's office that had more experience, but you know, when we took on the role of adopting regulations, I got the privilege of going to the Office of Administrative Law's 3-day rule school, where it was like basically a crash course on the APA, the Administrative Procedures Act, to learn how to go about adopting regulations and all the procedures that we need to follow in order to do that. So this is something that was pretty new to our section, definitely new to me. I had never worked on rulemaking prior to this. So it was something, you know, exciting and new for us to do, but it's something that we have taken on with great, you know, we appreciate the responsibility that has been given to us, and we work on it. At least, you know, I know that me and my team, colleagues work on it very, with great gusto, I guess, excitement, and with great, what's the word? Like, we take it seriously, obviously.
Yeah. Well, and this is such a treat for us to have this conversation with you. And again, as I said, you know, you are an active member of this bar, and you are, you know, part of this community. And the reason I like to say that is because you read every single comment that was submitted.
Oh, yes.
And,
I did.
And that's why it's so amazing that you're sharing this insight with us, because you're the one that read all the comments. You're the one that responded to all the comments. You're the one that put pen to paper in terms of the regulations. So I wanted to kind of go to the next slide.
Oh, but I do want to say, not to downplay, there are many people in our section
Yes.
that did everything. I think I read everything, but you know, we did split up some of the responsibility. It was a momentous task, and so I don't want to downplay any of my other.
No, I mean, you specifically did, but obviously there was a team, and what I understand is, you know, this is my slide, so I'm gonna add, you know, focus that this is not the AG slide. We're gonna share some slides that Lisa has shared with us, but these are the kinds of topics that we have seen in terms of enforcement priorities and the kinds of issues that we're working with businesses. And I understand that it's not just Lisa, although Lisa is in the role of enforcing CCPA right now. There is a team, several DAGs that are charged with enforcing the CCPA. And this is not by far the full scope of the issues that you have seen. So let's get into some of the lessons learned. We are so excited to be really kind of hearing directly from you, because as we were preparing for today's webinar, you know, you said that you pay attention, that you listen to some of the things, some of the events, and some of the things that the practitioners are saying, and you want to kind of share directly from the AG's office your perspective in terms of the kinds of non-compliance issues that you have seen. So thank you for that. Thank you for kind of talking directly to us. So tell us a little bit about the current enforcement process. I think the reason that there is a lot of speculation, people trying to guess, you know, what your priorities are, and you know, and practitioners like us, we have kind of limited view, you know, to the extent that we have kind of view on the ones that we are working on. But none of the enforcement actions so far have become public. So what insight can you give us on how many notices of violation have gone out since July of last year? And what's the kind of timeline that you can share, you know, from the moment that a business may receive a notice of non-compliance, like what could the business expect?
Yeah, so that's a great question, and I'm glad to answer it. The CCPA gives businesses 30 days, quote, after being notified of alleged compliance to cure the alleged violation. And so, basically our process is that we've sent out dozens of notices of violations to businesses about alleged noncompliance. And there is a 30-day deadline by which we ask them to respond to us. We welcome businesses to contact us in advance if they like to confirm receipt, as well as if there's need for clarification on any of the alleged noncompliance that's written in the letter. So we definitely are receptive to that. I want to note a few things about this notice of violation or alleged violation. First is that the CCPA says that the business need only be notified of alleged non-compliance. It does not specifically say the AG shall notify the business. So I want to provide this caveat because if there's evidence that the business was previously notified of non-compliance, perhaps through a consumer directly complaining about things or that sort of thing, we may and we will use our investigative resources as appropriate to determine whether or not that notice of violation was given to the business prior to that 30-day mark. And I think our notices of violations that go out include some like alluding to that issue. So I just want to clarify that in case there was any kind of a misunderstanding of what the CCPA says. The other thing I wanted to note was that this issue as to what it means to cure a violation, the statute does not define what cure means, or at least specifically state that. And we as an office cannot and do not give legal advice to the business as to what it means to cure. That being said, is that what we do is we point to the specific allegations that were made and note that, much of the violation is fact specific. So, curing may require more than just a technical change. And, it's fact specific to the situation, as well as the alleged noncompliance. And we recommend, and we strongly recommend, that businesses don't wait to comply with the law until they receive one of these notices. It very well may be that it takes much longer than 30 days to cure certain violations, especially if it directly impacts the consumer's rights.
Mm-hmm. You made a couple of points that I just want to kind of underscore a little bit. First of all, you were talking about the fact that in terms of the 30-day clock ticking, that it's not necessarily from the moment that the business receives a non-compliance letter, that a letter from a consumer with a complaint that gives notice to the business that you might be in violation of the CCPA, that could start the clock ticking. My experience has been that in terms of the AG's letters, they have given us 30 days to cure, but I think what you're signaling is that is not really required. That the CCPA, that the clock really starts ticking when the business becomes aware of the issue. So I think that is a really important point, and I'm not sure that the business have really kind of heard that. So thanks for clarifying that. Another point that you made that I think is really definitely true is the fact that the AG's office has been quite receptive in terms of entertaining meetings, kind of in or outside of this kind of 30-day window. So that definitely has been our experience. We appreciate the fact that we are able to talk with the AG's office even before the 30-day clock has run out. And then the guidance that we have received has been very helpful in terms of thinking about how to cure some of the alleged non-violations. So then, to the extent that the 30-day clock doesn't necessarily start, but it tends to start in terms of the AG's prosecutorial discretion and the enforcement. Can you give us some examples of violations that you can share and that you have seen that the business have found difficult to cure within the allotted 30 days?
Well, I could just point to the fact-specific nature of the allegations made as well, what we alleged as being non-compliance. Like, for example, a technical change may be, okay, you didn't include all the rights that, a consumer has in your privacy policy. That might be a very simple technical change that can be done within 30 days. But one area that might be harder, questionably harder to cure and, may be more difficult to cure is, for example, if if a business claims that it's not selling personal information, when in fact that they are, because they're not complying with the law, then how exactly do you cure that within 30 days if you don't have any of the processes in place to acknowledge that you are indeed selling personal information? So that's the kind of specific allegation that a business is receiving this notice would look at to really understand what is the deeper nature of the alleged noncompliance that's taking place.
That's really helpful to know. And again, I would like to kind of highlight the fact that the examples you gave us are not related to data breach, right? I was talking to one of our data breach kind of litigators at Baker, and he was asking, what data breach occurred at the business that may have resulted in the AG investigation. That's not true at all. This particular investigation was not related to a data breach, like a publicly reported data breach. And so the examples that you're giving and some of the non-compliance letters that we have received are relating to consumer response. It's relating to notice, is relating to the different kinds of kind of policy and consumer response procedures, which are not related. There was no hacker, there was no malicious actor involved in terms of theft or unauthorized disclosure. So the next question that we get often from our clients is, when do these investigations become public, right? Because if it was a publicly reported data breach, obviously everyone knows it's public. It goes on the California AG's website. I have to give a plug for the California AG's website. The privacy section has a fantastic website with all the resources where you can look at all the enforcement actions, list of all the privacy laws, and also the data breach reported incidents. So please do check that out. I love using that website as a resource. So what you are describing, some of the non-compliance letters that you have sent out, they're all confidential so far. When do they become public?
Yeah, so, to address any comments out there or rumors or murmurings that I sometimes hear that we're not really doing anything in our office or we're not enforcing this law, that's definitely not the case. As I mentioned earlier, we're sending out dozens of notices of violation. Our investigations are confidential for a number of reasons. One of which is fairness to the business who is coming into compliance, because there's no violation until they, if they cure their violation within the 30 days of notice. What I would say is that I can think of 3 different ways that investigation can become public. One would be, for example, if our investigation proves that there were violations that took place and there was no settlement that we decided to enter into, or if there was not cooperation by the business with regard to resolving that issue, then we'll file a lawsuit. And that lawsuit is a public record, obviously filed with the court, so then it becomes public there. Another instance is if we determine through the investigation that there indeed were violations that are prosecutable, and then we generally approach the business and ask them if they'd like to engage in discussions of early resolution. So if we settle a case, what the settlement always entails is that they are never confidential. To dispel any kind of notion, and this often happens because it's different than private practice, is that any kind of settlement that is entered with the AG's office, our office, or our unit is always public. It takes the form of a stipulated final judgment. So essentially what takes place is that there's a complaint filed with the stipulated judgment filed at the same day. And so it's all a public record. Typically, our final judgments always include some type of injunctive provision as well as penalties. So if there's a violation that has taken place, it has not been cured, and we decide to prosecute it, then it's going to be public. Another instance I would say is that it could be public through the investigation process. If we serve a subpoena and the business is not complying with the subpoena, we can enforce that subpoena with the court, and that would make it a public record. So there have been instances in which our investigations become public because of that reason. But that would be the ways that I can think of.
That's really helpful. Thanks for outlining that process for us. I think what you said about none of the settlements being confidential, I think that's really interesting because that kind of makes me think about what you said earlier, right? We were talking about violations that might be not curable. There is nothing you can do to kind of claw back the data that's been shared in an unauthorized way or, used in a way that is not covered by the notice of collection, for example. So I think there are some definite things that business can do proactively now and not wait for the non-compliance letters because there are some things that are just not going to be able to be cured.
Yeah.
Okay.
Good way of putting it.
I'm just kind of taking mental notes as I go. So now that the AG's office has been enforcing for a little over 9 months, tell us how it's going so far. What are some takeaways? What's your advice in terms of businesses, how to engage with your office, how to respond, any kind of practical tips for how to, if there is an enforcement action, or in general, in terms of how to think about putting together a compliance program for CCPA?
Yeah, I mean, I want to point out, and you kind of alluded to this too, is that we, our office, we're watching things, we're working, but we're also have our ears and eyes open. And we've seen, on the most part, I want to emphasize this is that majority of the companies that we have reached out to with regard to these notices have complied. Majority of them are making efforts to come into compliance with the law, and it's really encouraging for us as a office to see this happening. We hope that it continues to happen, and we also notice that companies are talking with one another, whether it be through their counsel or through these panelists. Like we've seen, we're members of the bar too, so we see these MCLEs that come out, and we're watching, and we see what practitioners are talking to each other about. And I want to say that in some ways they get it right when people are sharing, oh, this is what we think the AG is doing. In some ways, I think they get it right. But I also have to say, I think in some ways they don't get it right. And I have to say that that was part of the impetus that moved us or convinced us to speak with the CLA, or at least for me, is because there are some wrong takeaways, and I wanted to address them, or I wanted to address them here. And we can start off by just, these are some lessons learned with regard to, lessons learned about what we think businesses, maybe businesses or perhaps even the privacy attorneys advising them are misinterpreting the CCPA or not reading it or the regs as explicitly as, we think that they should be. And I wanted to start off with maybe privacy policies.
Mm-hmm.
So we've heard criticism and murmurings that it's very challenging to be concise while still communicating all that they have to communicate in a privacy policy. And I want to be clear in the sense that there's nothing in the CCPA or in the regulations that says a privacy policy has to be short. I think all of us know that it would be very difficult to keep your privacy policy short if you were to include all that is required by the CCPA. What the CCPA says and what the regs say is that the privacy policy has to be clear, that it has to be easy to read and understandable to consumers, and that you're supposed to use plain, straightforward language and avoid technical or legal jargon. That is what the CCPA requires. And so I want to say this very clearly, and my takeaway is that the privacy policy is for the consumer. It is not a CYA for the business. We have said this for years, that you should say what you do and do what you say. And that is especially true with regard to the privacy policy. You should be clear in the privacy policy. And it is meant to inform the consumer about what the business is doing. So it should really be read through the lens of a consumer, not through the lens of an attorney. If your elderly parent, if your teenager doesn't understand what you're saying, then you really need to rewrite it, because this is the California Consumer Privacy Act, and it will soon be the Consumer Privacy Rights Act. And so it's focused on the consumer, albeit while considering, the burdens that it may place on the business. So while many, people who are listening today are maybe focused on how to advise the business about how to comply with the law, I want to point out that everyone sitting in the audience is also a consumer. If you're an attorney, a privacy attorney, you're a consumer as well. So it's really my responsibility to protect you and all of us as consumers, myself included.
Yeah. No, thank you for that, and I appreciate it, because CLA, we represent obviously in-house counsels and law firm practitioners like myself who are advising businesses. But we are a big tent, and we have folks like you, who are in a regulatory role. We have people that are in consumer advocacy and representing kind of the consumer interest. And so, absolutely, from a CLA perspective, I think it's really, really helpful to kind of hear you kind of stress that the role of privacy policy should be about really informing the consumers what the privacy practices are. So, as we were preparing for some of the lessons learned, I think you said it as kind of setting the record straight in some of these topics. So let's, this is going to be a rapid fire round of questions for you. So first was privacy policies, as you said, and thank you for explaining that to us and really kind of setting the stage. Second issue that you want to kind of talk about is
before we go on,
yes.
I do want to make some examples. Like, if I were to flesh out some of the examples for the privacy policies, and I think that this might be helpful, is that, some of the examples that I would describe as not being clear and easy to understand would be complicated charts that require you to cross-reference different sections of the privacy policy, like where it's not just like saying this is the type of, like where you're like literally scrolling up, scrolling down, it says section B, C, D, E, F, or something like that. That's not easy to understand or easy to read. Lots of legalese and generalizations and, use of the words like as required by applicable law or in accordance with the rest of the privacy policy. I'm not don't get me wrong, don't twist my words. I'm not outlining that those phrases are not necessary, or you can't use those phrases or something like that. But I just want to say, is there a better way to say it? Like, what do you mean when you say something like that? Are you hiding behind this language? Because, I was a defense attorney too. I represented big companies for 12 years prior to coming to the office. Like, lawyers are really good about keeping really generalized language so that they can kind of, fit everything else into that language. But, that doesn't mean that it's clear or easy to understand for the consumer. Using terms that are not defined, but they're very industry specific and harder to understand. Like, for example, the word processor without defining what it means. Like, I know it's a very, legal term used in GDPR and stuff like that. But like, if I were to show that to my kid who's 14 and say, do you know what this means? They'd be like, I don't know. Like, I have no idea what you're talking
about. So is your son getting a copy of the privacy policy to read as a test?
Yeah, I mean, I'll tell you right now, absolutely. My kids are not allowed to download any mobile app until they've looked at the privacy policy and can explain to me what is happening and whether or not, at the very least, that mobile app is selling their data. So, our privacy team have lots of kids, lots of parents on our team. We've always, our prior AG always said that, issues about concerning minor privacy was always important. We have little kids who don't download apps because they know their parents won't let them, that kind of thing. So, if you, test out your language on regular people, pick someone in your business that is not a privacy, on the privacy team, or a lawyer. Like, pick your just random, office worker and say, hey, read this. Does this make sense to you? What do you think it means? That should really be the test. I mean, I'll tell you right now, and I've said this specifically to businesses when I talk to them, is that I've read a ton of privacy policies. And I, as an educated attorney with several years of privacy experience, if I don't know what you mean, then, or if I think you're hiding behind clever language, then it's not complying with the statute or the regulations. Like, I shouldn't have to be second guessing what you're saying or asking the question, what do they really mean when they say this? I think that that's probably a common sense standard. You have to take a step back and actually really, take that lens to your privacy policy. Sorry, I
Thank you
wanted
for
to add
that.
that in there.
No, the examples are, I know that we talked about the examples when we were preparing, and so thank you for reminding us about that. And that's really helpful, especially those concrete examples that you're giving us is really helpful. And I think one of the areas that the next topic that we're going to go to is exactly an example of what you mean, because the question about sale, because as you know, the businesses we've been kind of struggling with, what is the definition of sale? What is a sale in a traditional kind of dictionary sense is not what a sale is under CCPA. And so I think as lawyers, we've been having a hard time trying to explain in a way that is consumer friendly, in a way that a 14-year-old would understand. So we've ended up saying things in the privacy policy, things like, we don't think this is a sale. We don't sell for monetary purpose. But to the extent that CCPA considers this a sale, quote unquote sale, here's your opt-out right. That's kind of the reality that we ended up with, because we're trying to kind of balance this notice that we need to give in terms of right to opt out versus, on the other hand, I guess trying to kind of educate the consumer that might have never read the CCPA and never heard about CCPA maybe. What does this sale concept mean? Because we also don't want our customers, from a business perspective, we don't want the customers to think that the business is selling the data when we're not. But maybe they're doing some activity that falls under definition of sale, maybe. So tell us a little bit about the kinds of non-compliance issues that you have seen related to do not sell, the link, and also the kind of consumer response procedures that were associated with the opt-out right.
Yeah, thank you very much for asking that question. With regard to the do not sell my personal information link, I believe the CCPA and the regs are very clear on what a business is required to do with regard to the do not sell link. To take a step back and address the sale issue just from a very high level, I want to say that, the ability to exercise your right to opt out of a sale is supposed to be easy. Mm-hmm. I think that is clear from, the preamble of the CCPA, and, you'll see it reiterated again with regard to the CPRA, but it's a fundamental right given in the CCPA. And we're very much focused on this idea that consumers now have a right to tell a business to stop selling personal information about themselves, and they should be able to exercise that right easy, like in an easy way, that there's no, you'll see this with regard to our dark patterns regulations that have come out or gone into effect recently. Faulty do not sell my personal information links and dark patterns that try to obscure or lead the consumer on like a scavenger hunt as to how to exercise it. That is not okay. And that is not, we are not okay with that. I'm not okay with that. And we will definitely be enforcing, that to make sure that consumers have a meaningful opportunity to exercise that right. Mm-hmm. I can walk through what the CCPA says, or specifically what the regs say, because, I helped put them together. But the do not sell my personal information link should take you to the notice of right to opt out. And that notice of right to opt out basically says you have this right. And then it has to include the form or a means in which that consumer can exercise their right. So, it has to go to a mechanism by which the consumer can effectuate that right. Mm-hmm. Now, you can't just link to the top of a privacy policy. That is especially annoying, I think, to me as a consumer, is when I click on the link, it takes me to the beginning of a privacy policy. I have to scroll down through like multiple pages until I can finally find here's my California right, and here's how I effectuate it. If you're linking to a privacy policy from the do not sell link, which is allowed, it should go to the section that talks about this is your right, with all the information that's required to be included in the notice of right to opt out, and the mechanism by which I can exercise that right. So if I can give this takeaway to businesses, or in general to practitioners, is like, don't be sneaky on this point. Like, CCPA requires an easy opt-out. It's a fundamental right. Don't make it hard for the consumer to exercise it. The dark patterns regulations say that it should be as easy as opting in. If you're making it really easy for a consumer opt-in, then that opt-out right should be just as easy. we are enforcing this part of the statute. We're gonna continue to enforce this, aspect of the statute with great fervor. And if I can also just add one more point, it's a note on the CCPA framework. We enforce the CCPA, right? So the CCPA replaces responsibility on the business to comply with a consumer's request to opt out. And remember, sale is broadly defined to include if a business makes available personal information for consideration or for valuable consideration. So it is the business's responsibility to effectuate the consumer's request. Like businesses shouldn't push back the responsibility back to the consumer, and they shouldn't be tasked or burdened with self-managing the opt-out by being directed to various third parties to whom the business sells the personal information in order to effectuate their right. It's the business's responsibility to respond to that right. And that's how the CCPA is framework. That's the CCPA framework, and that's what we're enforcing.
Mm-hmm. That's really helpful. Again, I'm going to try to kind of underscore what I just heard. I think I heard two things. One is that when you click on the opt-out link on the home page, that it should not go to, it shouldn't get lost. Consumers shouldn't get lost, right? Like they shouldn't go to the top of the privacy policy. They have to scroll down. A couple of other things that I think businesses have been doing is there is like a general consumer response, like a center. And then you have all the different rights and all the different things. And that's one thing that I've seen our clients do. And then also, as you said, use of the third party. So it sounds like to the extent that there is an opt-out link and it's going to some other page, what you are looking at is for that page to be a deep link, that notice the right to opt-out is right there. And to exercise that opt-out is really easy. That it should not be, ending up somewhere where the consumer has to kind of figure out, how to exercise that right. And same thing with the third parties. If you are using a third party, that it is not kind of pushing that obligation back to the consumers. That this is really something for the business to execute on. Yeah,
I mean, I think that's where I'm seeing that. Sorry, my emergency alert just went out on my phone, so
okay. I apologize. Are you okay to continue?
Yeah.
Okay.
There's
that's really helpful. And I know that I've asked you this question, and you can't tell us, it's 2 clicks okay versus 3 clicks okay versus 5 clicks. You can't tell us that. But I think what you are pointing to is basically kind of go back to what the statute requires in terms of making it easy.
Yeah, and like if you look at the dark patterns regulations that pertain to the exercising the right to opt out, that's we put in a performative standard as the first one, which is basically, we know businesses are incentivized to have the consumer opt in to the sale of their personal information. And again, CCPA, does not require that consumers opt in. We're referring to opting in after you've already opted out or something like that. But if it's easy, we know businesses can make it easy, because they do it for, situations in which they're incentivized or it's in their own interest to, to make it easy. So we expect that you use that same kind of mechanism, or like the ease with which you want to make it a frictionless way for consumers to opt in, then you know how to do it for an opt-out. And we expect that it be done that way.
I think that's a really interesting point. So if you are having kind of granular opt-in to receiving XYZ marketing emails, that should be almost as easy as kind of opting out. I think that's an interesting point. Let's go to the next topic. The next topic that you want to talk about is about service providers, which again has been an area that has been really challenging for the businesses to identify in terms of which third parties are collecting or are receiving personal information, and which of them qualify as service providers. So in addition to the data mapping and the vendor risk assessments that the business have been doing in the last year and a half, one of the major CCPA requirements has been to have a written contract in place with the third parties that restricts the data usage to what the CCPA would permit. What are some non-compliance issues that you have seen in terms of how the businesses are complying with the service provider requirements?
Yeah, so, to take a step back, what the CCPA, what the CCPA says is that personal information that is shared with a service provider is exempt from the definition of sale. That's what the statute says. But, at the same time, the definition of service provider is very clearly set forth in the CCPA, and it's also further interpreted by the regulations. That requirement for a service provider is that there has to be a written contract in place, and that written contract has to have restrictions on the use of that personal information by the service provider, and whether, restrictions on the service provider's ability to further use or disseminate that personal information. I would like to point out, regulation 999.314 that has to do with service providers, and specifically subsection A, because subsection A is very clear, and I think people are not seeing this or understanding it, but it says that a service provider cannot use personal information from one business to service another business. That takes it outside of the definition of service provider. Similarly, with regard to subsection C of 999.314 is that, a service provider can use personal information to improve its services, but that excludes any kind of profiling. So you have to understand, and I think we state this in our final statement of reasons, is that, businesses should be very careful whether or not they are truly giving information to a service provider. Because if a pseudo service provider, or someone you think is a pseudo service provider, is not contractually a service provider, then you're essentially, selling personal information. Or what's the default? It means you're selling personal information because you no longer fit within the definition or the exemption provided in the definition of sale. So I would strongly recommend that businesses take a look at their contracts. If you do not fit, if you're giving information to someone who does not fit within the service provider, that exchange may be a sale, and you may have been selling this whole time without complying with the provisions of the CCPA with regard to giving consumers a right to opt out of that sale. We are looking at these contracts. We are looking into this issue because the right to opt out of sale is a very fundamental right, as I mentioned before. So, we are definitely looking at this issue.
Mm-hmm. I'm gonna just let what you just said sink in, because you just gave us some really good practical advice. So first, fundamentally, there are some business relationships, what you're saying, it is not going to be a service provider relationship because of the use of the data. So you are making a distinction of how the business is using it for their own purposes. Outside of that kind of fundamental business relationship, the second question is, did you have a written contract in place, which is the more technical requirement? And then third, even if you had a written contract in place with the service provider, did it have the right restrictions? And all of those things, if all of those three things are met, then the third party will qualify as a service provider. If not, the next question is it a third party, right? And then the next question that you're going to get into is, how do you, to the extent that this third party that you are engaged with, where you are exchanging personal information, is not falling in the service provider exception, and you have a separate set of obligations to meet as a business that is exchanging personal information with a third party. So tell us about that. What are the kinds of takeaways that you can share with us in terms of non-compliance related to third parties that are not service providers?
Yeah. So, with regard to third parties, the one thing I want to speak to is that, paying for services alone may not take you out of the scope of sale. Again, this definition of sale is broad, and it's not just limited to monetary consideration. It has to do with other kinds of valuable consideration. So just because you're paying someone that you're providing information to provide you with services, that alone may not be enough to take it out of sale, because there may be some other consideration that you're receiving because of that, because of the provision of the provision of that information to the third party. And, I would, for that reason, I would say that businesses should look critically at their data flows, especially with regard to when that data is flowing outside of the company, and if there's no obligation on that third party to restrict the use of that information, or the further dissemination of it. Like, to the extent that you claim that you do not sell personal information, but personal information is still flowing outside of your company with no further protections, like protections as restrictions on use or further dissemination of that personal information, we'll probably take a closer look to determine whether there's some kind of benefit that you receive, that the business received, to determine whether or not this was a sale. So that's what I would just say with regard to that issue.
I'm going to go to the question that probably everyone wants to know, because what you just said, to qualify what you just said, it's not just about data flowing out of the businesses. You said before, in terms of CCPA obligation to the businesses, making data available would fall under, in terms of quote unquote transfer to a third party too, right? So the question that we get is, are third party cookies a sale? To the extent that personal information is not necessarily, it's not being sent in a spreadsheet, right? We're not talking about an attachment with millions of rows. Theoretically, it could be making personal information available to the extent that you're engaging with these third-party cookies. So what can you tell us about cookies, and any practical advice, from having lived through some of the enforcement investigations that you're doing? What are some non-compliance issues related to cookies that you can share today?
Yeah, so if it isn't obvious by now, like from what I've been sharing, we are taking a real look at companies that are using tactics related to the sale of personal information that are in violation of the statute or does not fall within an exception. So, we're looking at, whether you're being sneaky and trying to like go around these clear definitions or framework in which gives the consumer a right to opt out of sale and that sort of thing. Depending on the context, what I can say with cookie banners is that it's probably facts. It is likely fact specific. And it may, for example, it may be that a business is relying on a GDPR cookie banner consent as some type of indication that the consumer is intentionally directing the business to disclose the personal information, and so they're somehow relying upon that as being an exception to sale because the consumer directed it. While this may, while the cookie banner may satisfy GDPR obligations of obtaining general consent, it may not meet CCPA definitions of agreeing to the sale of their personal information. I can point at least to the statute that talks about how consent cannot just be closing a window or hovering over a window or a pop-up or something like that. I can't say definitively one way or another because certainly, this is a fact-specific inquiry or investigation. But I do have to say that we are aware of the use of these cookie banners. We are kind of watching it, and we're continuing to watch it, and it is something that we may start digging around and thinking about it, but it's on our radar for sure. So that's what I would say. It's like, if I can say anything, it's just like from a personal perspective, if I were a practitioner advising a company, like look at the statutes that relate to a cookie banner. Like, is it notice at collection? Is it right to opt out of sale? Are you complying with the other obligations there? Are you complying with the spirit of the law, which is to make the right to opt out easy? Or are you trying to sneak around and do something kind of trying to fit into an exception that may not be really that just may be distasteful? And so I take a common sense approach to these things. It is something that's on our radar. It is something that we may investigate, or may already be investigating. I'm not going to give one way or the other speak to that issue.
Right. And I know that I've asked you a couple of follow-up questions on this matter, and you're just not at a time to disclose. So thank you for giving us some insights on this, as this is a topic that is kind of front of mind for a lot of the folks. We have here the final statement of reasons. Thank you for sharing with us these two slides. One about this final statement of reasons, and then the next one we're going to talk about for CPRA. I think we're going to start talking about. So I think the takeaway here is really for all of these questions, very complex questions, whether it's on the notice question or on the do not sell, consumer response procedures, or opt out and cookies and service providers, I think the takeaway for me is read the law, read the regs, read the FSOR. You make use of all the resources you have. And I have found the FSOR to be tremendously helpful because, again, you're really kind of responding to every single comment, every single kind of changes that you have made to the regs, and kind of explaining why certain regs are the way they are.
Yes. And that's a requirement of the APA. Like, there's a narrative portion of the final statement of reasons that specifically, articulates what's the necessity for this regulation, why was it created, what is it meant to do, and then we have like all the appendices that responds to every substantive comment that was made about the regulations. We're required by the APA to basically state this. We're required to say, to a comment, a substantive comment, yes, we accept it, or no, we don't accept it, and here's the reasons why we don't accept it. So there's a lot of information there that might be very useful to practitioners and companies who are complying with the law or trying to, implement the law. There's a lot of information in there.
And one of the kind of a practical tip that I like to share is I just do a find. I just do a Control F. Whenever I'm looking for a specific section, or like the service provider, you alluded to the section 314. I look at subsection A and subsection C of the 314 section all the time because there's just such good guidance, in those subsections. So it's really well organized. All of the comments are organized by who submitted them and the responses to each of them. The FSOR is organized by the section. So if you have a question about a specific rules, within that section, you can look it up by the subsection. I do a word search, and whenever I have a question, access, deletion, authorized agent, whatever the question is, I do a word search on the FSOR to kind of make sure that I have gotten everything that I need to get out of what you have publicly shared with us. So,
and just to know, in case anyone wants to know where it is, it's on our it's on our AG's website. It's, I want to say it's like oag.ca.gov /CCPA or something like that. But it's certainly easy to find. Mm-hmm. You can download it. It's in a searchable PDF. I think even the final statement of reasons might even, well, at least for the dark patterns one, I know that is like one document and has bookmarks. So it should be easy to like navigate. So it's all there for the public consumption.
Thank you for that. Thank you for making it so easy to digest. So we're going to go to CPI rulemaking. I know that we could probably talk with you for hours, Lisa. There are many more questions that we have, but thank you for sharing the insights with us today. So now that we are kind of looking ahead, in July is when CPRA rulemaking is supposed to begin. And, we just saw the CPPA, the California Privacy Protection Agency Board, just get nominated. And so can you tell us a little bit about what are some lessons learned? What have you learned from having been kind of the lead attorney on the CCPA rulemaking? What do you think is going to happen in terms of CCPRA rulemaking? What is the AG's office role? For you personally, what is your role going to be moving forward? And I'm going to put here on the slide, these are some additional consumer rights and enforcement regime that you are kind of taking a closer look at. So obviously you are kind of starting to look at CPRA while you are still enforcing CCPA. So thank you for the slide from the AG's office. So what can you share with us in terms of CPRA?
Yeah, the talk was lessons learned from CCPA enforcement and lessons learned from CCPA rulemaking. Under the CCPA, there was, I believe it was like 7 categories in which we were supposed to adopt regulations about. Under the CPRA, I think it's something like 22. Mm-hmm. So rulemaking is not going away. With regard to the role that the Attorney General's office is going to play, like we currently have the authority to adopt regulations right now. That according to the CPRA, what the statute says, that is eventually going to be transferred to the new privacy agency. it's not exactly clear in the statute as to when that will occur. It's interesting to note that the statute kind of has two conflicting statements. One says like the earlier of two dates, like 6 months when they give notice, or July 1st, which one is earlier. And then in another section of the CPR says whichever is later. So I'm not exactly sure how that's going to work itself out. But you know, what I do know is that from my experience in CCPA rulemaking, it takes a good part of a year to do the rulemaking. And given that, you know, the regulations have to be out by July 1st, 2022, I believe, you know, that process is, you know, probably needs to get started soon. It's a lengthy process. It is governed by the California Administrative Procedures Act, like I mentioned before. It requires a lot of input. You know, there's a notice. The actual start of the formal rulemaking process is with the notice of proposed rulemaking.
Just like CCPA.
Yeah, just like CCPA, and the APA requires that it be done within a year, or you have to start all over again, essentially. With CCPA, it was extended a bit because of the global pandemic and the governor's orders that gave additional extensions to that time. But generally speaking, that's how it works. What, you know, I want to give more helpful tips, I guess, and I don't know if it'll be us who's working on the rulemaking. I know that, you know, we're still waiting for, you know, some of these rules to flesh itself out, or, you know, I'm kind of low on the totem pole here, you know, with regard to, you know, what exactly I'm doing. I just know like how the process worked with regard to the AG's office. And I also, because I was intimately involved with the process, I can tell you from my perspective what was helpful and what was not helpful when it came to the rulemaking process. And so if I could just give a few tips, I know that we only have 3 minutes left, you know, helpful things that I found really helpful during the process is, you know, real life examples, like including factual understanding with regard to, you know, if a proposed regulation is out there and it's going to break every system that your business is, you know, working on, then tell us about it, you know, explain to us why that is the case. You know, I would think that, you know, if you paid any attention to the first rulemaking process or with the CCPA, is that we listened to those comments and we modified regulations based upon the comments that we were receiving. It happened with regard to service providers, and it also happened with regard to offline collection notices at collection. So, you know, this is really an opportunity for businesses to vocalize and explain, you know, the impact that a proposed regulation may have on their business and why. And if you want it to be compelling, then give us some specifics, explain why it's the case. And I know it's unfortunate because a lot of businesses like don't want to out themselves or put themselves out there by putting out this public comment. And I really think it's really unfortunate because the whole purpose is for us, you know, for the regulators to receive feedback as to the actual implications of these rules, and to explain away, to the extent that that's not adopted, why, you know, the change was not made. So this is really your opportunity to do that. Include, you know, it's helpful to include factual information, scientific reports, journal articles, you know, consumer reports. When we were doing dark pattern regulations, they submitted a do not sell link study that they had conducted. I mean, we were already looking at this stuff, but it was really helpful to see. And we, in the end, you know, included it in the documentation that we relied on when we put out the dark patterns regulation. The other things that I would say would be helpful is, you know, provide alternate language. We don't always adopt it, or at least in our experience, we didn't always adopt it, but it was helpful for us to see how it was framed by people. And what I would definitely say is use headers and bullet points. Like, you know, for me on a pragmatic level, it's just like if you're a litigator putting, you know, court papers before a judge, make it easy to read, because most likely they'll receive it and read it easier, and, you know, the comprehension level will increase. So, you know, be effective in your writing. Use headers and bullet points for each different substantive point. It'll help us to be able to address it and respond to it. As to not helpful with this last minute, I would just say, you know, lengthy summaries are not helpful to me. I didn't think so, because especially if you already have the distinct points being listed out later on, if you just kind of combine it and put in this big intro paragraph, you still have to like break it down into substantive points and respond to it. And it's kind of annoying. Personally, I found that to be the case. And like, you don't need to repeat yourself. You don't have to come to every single oral hearing and say the same thing. You don't have to submit your old written comments over and over again, because we're already responding to them. We're required to respond to them the first time. So, save yourself the work. Save yourself the work. And, what I would say also is that, asking for very specific regulations that are very specific to your particular industry or your particular business, personally, I do not find those to be very appealing, because you're either asking us to do something out of our authority to do, or you're it's not necessary for us to do it, because maybe there's enough like leeway within the CCPA to give you discretion to do it. So especially from CCPA standpoint, our focus was to make the CCPA work. We had a lot of rulemaking authority, but we couldn't handle everything. I mean, you could the CCP alone, like our FSOR was 600 pages. So can you just imagine if we threw in some, a lot of little things, like we were focused on getting the bulk of it done. I imagine that might be the case too with the CPRA. First, we have to get it functioning, and then we can go into nitty gritty kind of thing. So because rulemaking is ongoing, it's going to continue. The privacy agency is probably going to continue doing it over time. So that's the perspective that I would provide with regard to the CPRA, or with regard to the rulemaking process in general.
Thank you for that. I know that we're just out of time. You gave us some really practical tips and insights into CCPA enforcement. And I want to also highlight the fact that CCPA is going to be enforceable until January 23, 2023, when CPRA goes into effect. And even after CPRA goes into effect, the California AG is going to retain its enforcement authority, while the CPPA takes over the administrative authority for fining. So that's really helpful, that you and the rest of the team at the DOJ California is going to continue to help us understand how to comply with these. So to that extent, thank you again for sharing these insights. I'm going to just let you know that there's a couple of different slides here that we've included here to let you know, obviously, AG is not the only way that CCPA is getting enforced. We have private right of action under CCPA. CCPA is not the only law. There are over 17 different states where CCPA-like law is being considered. So obviously, as practitioners, we need to look at this holistically. So we like to think about how CCPA falls in the context of the larger privacy landscape. As I said, there's Lisa's bio there. There's my bio and my contact information, and some information about joining the California Privacy Bar and some of the upcoming events. And again, thank you to IPP for co-sponsoring. With that, we're going to close. Thank you very much, Lisa, for being an active member of the bar, speaking with us and sharing your insights. Really appreciate your time today.
Thank you very much for the invitation to speak, and I appreciate this opportunity.
Thank you, Lisa. Bye-bye.
Bye-bye.